2025 CR 004587 State versus Jamison Franklin. Could I have parties announced?
And Jonathan Alvarado for the defense.
And are you Mr. Franklin?
Yes, ma'am.
All right, did you review the document entitled Motion to Revoke Community Supervision and First Amendment Motion to Revoke Community Supervision with your attorney? And did you understand it?
Okay. So, Judge, I apologize. I have not gone over the First Amendment with him. I just show it to it real quick.
Okay.
This was what we found on the older case.
Can you do it on like the third or something?
Yeah.
Wait, let me just check. Just 1 second. Oh, I'm sorry. Off the record for a moment. All right, the second is fine. Yes. And we're back on the record, Cindy.
Okay.
Wait, no, that's what I'm saying, but just so you have noticed it was.
Okay.
No. All right. So, Mr. Franklin, did you have a chance to review the motion to revoke community supervision and First Amendment motion to revoke community supervision with your attorney?
Yes, we just,
And did you understand it?
yes,
Are you the same Jamison Franklin who was placed on community supervision for the offense of manufacturing delivery of a controlled substance penalty group 1, 4 to 200 grams on July 24th, 2025 for a term of 8 years? Is that you?
yes.
All right, state.
On state's first amended violated condition number 1 on or about the 3rd day of December 2025 in Bear County, Texas. The defendant Jamison Robert Franklin committed the offense of possession of controlled substance or violation of condition number 1.
How do you plead to that? True or not true?
Not true.
Violated.
Well, I mean, if he's pleading not true, today is supposed to be set for a contested. Are you all?
So,
Do you want to?
I apologize, Judge. I didn't know exactly what the court wanted to do today because this is actually a First Amendment we were just handed today. These are new offenses that happened. I think the offense date is on either Monday or Tuesday of this week. And so I was going to ask the court for a reset at this point because of the new allegations. Additionally, Judge, I was not appointed onto the new cases. So I do not have the discovery as of yet.
So from the allegation, that's not the amended motion, but the original motion, the allegation of possession dated from December 3rd, 2025, you don't have discovery on that?
No, Judge, I do have discovery on that. I am the attorney appointed on that case. I would just ask for a reset, Judge, because at this point with the new offenses, I think it would be, for all parties and the court, it might not be efficient to try and proceed with those cases, the MTR today, when potentially we could wrap all the cases together. And I've conferred with the state on this, and that was kind of our approach to it, Judge.
So when is that going to be accomplished, if that is accomplished?
Well, I would need to get on the new cases or get the discovery in the new cases. So as soon as that could be done, Judge.
And are the labs in for the?
So, no, Judge, and the types of charges that the new cases are, we would not be able to proceed on the drug at this time because the turnaround for the testing, but there are 2 other cases that would potentially be able to be proceeding with the.
All right, and the other 2 cases,
It's a theft and a fraud use.
do you have discovery on those?
I do not.
All right, so he needs to have discovery on those. And Norma? Yes. This will be the last reset for this case. Set this for a contested hearing in 3 weeks.
Okay.
And just, for a painting, is Roger Bettis, so I'll contact Roger Bettis and see if I can just put Jonathan on there.
Okay.
And just take him off.
Thank you.
They're assigned to.
That works. Thank you.
I didn't assign.
Yeah.
3 weeks, Judge.
Yes.
That would be March 19th.
March 19th? Okay.
Okay. Thank you, Judge.
You're welcome.
Sorry for the confusion.
Oh, no problem.
You want to ask her about law? This case stands out not because of dramatic shouting or an immediate sentence, but because of the quiet tension that builds when a defendant's freedom is hanging by a thread. Jamison Franklin was already on community supervision for a serious drug offense, manufacturing or delivery of a controlled substance in the 200-gram range. That alone carried heavy consequences. He had been given 8 years of community supervision instead of prison time, which in many courts is considered a significant opportunity. Probation is often described as a second chance, but it is also a contract, and the judge made that crystal clear. The turning point in this hearing was procedural but powerful. The state introduced a first amended motion to revoke community supervision, alleging that Franklin committed possession of a controlled substance in December. Even more troubling were the newly mentioned theft and fraud allegations. Defense counsel was caught off guard by the timing of the amended motion and requested a reset in order to review discovery on the new cases. Strategically, that request made sense. No attorney wants to proceed to a contested revocation hearing without seeing the evidence. However, what elevated this moment was the judge's tone and clarity. She did not deny the reset outright. Instead, she granted it, but with a firm boundary: this will be the last reset for this case. That statement changed the temperature in the room. It was not loud or emotional, but it carried weight. It signaled judicial patience nearing its limit. In revocation proceedings, the stakes are extremely high. Unlike a new criminal trial, the burden of proof is lower. If the state proves even one violation by a preponderance of the evidence, the judge can revoke probation and impose the original sentence, potentially years in prison. Franklin's original charge was not minor. If revoked, he could face a significant prison term. The 3-week reset granted by the court is therefore not just scheduling, it is a countdown. Another layer of tension comes from the new allegations. Theft and fraud suggest escalating behavior beyond the initial drug case. If proven, they could paint a picture of ongoing criminal conduct rather than a single lapse in judgment. On the other hand, the defense's position indicates they may challenge at least some of these claims. A plea of not true forces the state to bring witnesses and evidence. The judge's insistence on efficiency also reflects a broader courtroom principle: probation is conditional liberty. Courts often give defendants opportunities, but they expect strict compliance. Multiple resets can signal delay tactics or instability. By setting a firm contested hearing date and labeling it the final reset, the judge reinforced accountability without appearing punitive. This case is compelling because it captures the fragile balance between second chances and consequences. Franklin is at a crossroads. In 3 weeks, he must either admit violations or force the state to prove them. If he contests and loses, prison becomes a real possibility. If he negotiates or pleads true strategically, the court may still modify conditions rather than revoke entirely, but that window is narrowing. Ultimately, Case 1 is a study in pressure. No shouting, no immediate sentencing, just a judge drawing a line in the sand and a defendant realizing that the next hearing may determine the direction of his future.